首先歡迎大家。
Welcome, members. This is the winter solstice, and I thank members for attending this AgendaI's panel meeting. Since the last meeting, we have not issued any information papers. As for items for discussion at the next meeting, apart from CB bracket 426/1415 bracket 01 list of outstanding items for discussion, we also have another paper, CB bracket 4220/1415 bracket 01, which is a letter dated the 28th of November 2014 from Dr Elizabeth QUAT to this panel, requesting to discuss the measures for handling sexual offence cases. There is also another paper, CB bracket 4264/1415 bracket 02, which is a list of follow-up actions. So, would members please note the letter from Dr Elizabeth QUAT dated the 28th of November 2014, requesting to discuss a matter in relation to CAP 221, the Criminal Procedures Ordinance, which we discussed last session in relation to the definition of witness in fear, and that when testifying in court, such witnesses can be provided with a screen or could make use of the televised link to give evidence and use a special access for accessing the court building. And you may recall that when we met with the Chief Justice, we also mentioned this to him. And the other request is about amending the Crimes Ordinance, CAP 200, to set out the criteria for judges to give leave and also to step up training for the legal sector and the police in handling the sexual offences. So if members agree, I will put this on the list of outstanding items for discussion of this panel. If we have time, we'll follow up on this issue. You may recall that last session we held a public hearing. So I see no members have objected, and I'll put this on the list. The next meeting will be held on the 26th of January 2015, Monday, 4:30 p.m., and the administration will discuss will give a briefing on the Chief Executive's 2015 policy address, and the Secretary for Justice will brief members on the relevant initiatives for the upcoming year, and the Home Affairs Bureau will also brief members on policy initiatives in respect of legal aid and legal advice services in the CE's Policy Address 2015. The Judiciary has also proposed to discuss a draft court procedural rules for the Competition Tribunal. This can only be confirmed in the first week of January 2015. So, if members do not object, I will first put these two items on the agenda for discussion at the next meeting. I see no objections here. And if the draft court procedural rules for the Competition Tribunal is not yet ready, we will advance some items first. We have also considered criteria for approving legal aid applications, and also a topic on legal education and the complaint mechanism, or a mechanism for handling complaints against judicial conduct. These items will be they are already on the list of outstanding items. And also we have another item proposed by Dr. QUAT, as mentioned just now. So basically, that's it. We move on to the next agenda item, the Law Reform Commission report on adverse possession. In accordance with Rule 83A of the Rules of Procedure, if members have any direct or indirect pecuniary interest on the issue to be discussed, please disclose the nature of the interest before the discussion begins. Adverse possession is also an item discussed last session. The relevant papers are CB bracket 4264/1415 bracket 03, which is an executive summary on Law Reform Commission's report on adverse possession, and CB bracket 4264/1415 bracket 04, which is a PowerPoint presentation materials on report on adverse possession provided by the Law Reform Commission. Also, CB bracket 4264/1415 bracket 04 is a background brief prepared by the Electoral Secretariat on Law Reform Commission's consultation paper on adverse possession. Another paper, bracket 06, a submission from the Hong Kong Bar Association. The submission is in English, and only English is available. The Law Reform Commission published the consultation paper last year in October 2012, which contained recommendations on reforming the law relating to adverse possession, and we had a discussion in 2013 February, sought members' views on this matter, and in the report published on the 20th of October 2014, the LRC made recommendations on reforming adverse possession law, and the Hong Kong Law Society has indicated that they will make a submission to our panel on this report. Let's invite Mr. Edward Chan, Chairman of the Subcommittee on Adverse Possession of LRC, to walk us through the report, and then the floor will be open to members.
The tentative recommendation on adverse possession were published in consultation in December of 2012. We have attended the meeting of this panel in February of 2013, and we have received over 110 organizations and individuals' proposals or comments on our views. Now, in preparing the final report on adverse possession, we have reconsidered those recommendations, taking into account the views that we have gathered from the public, and these are summarized in the report. The report contains two new recommendations, that is recommendation 9 and 10. They are basically to deal with particular decisions of the CFA, because it is the final court of final appeal in Hong Kong. We feel that if the law is to be changed by the court itself, it may take another number of years where a suitable case comes up and when litigation has reached that level. And having regard to the fact that we feel that the decision is absolutely wrong, we feel that the better way to do it is by way of legislation, and hence we make the recommendation. Now, the rules relating to acquisition of land through adverse possession are already contained in the limitation ordinance and also some case law. And basically, the period of the limitation period in relation to land owned by the government is 60 years. For other private-owned land is 12 years. That is the provision at the moment. Altogether, we make 10 recommendations on the topic. The first recommendation relates to the question whether there should be squatter title at all. And we come to the view that we should still have squatter title under the existing system. And in fact, from the comments that we receive from the public, the majority are in favor of retaining squatted title or adverse possessory title. There are, of course, organizations who are opposed to that. And in particular, I think the Hung Yi Gok is one of the leading organizations against any squatter title at all. Now, the consultation responses from individuals, however, is quite different. The individuals actually mostly feel that property owners should not actually lose their title to the property. That is counting in terms of numbers of individuals who have expressed their view. But having regard to the fact that we have had a long history of having squatted title, and also squatter title does have to solve certain of our existing problems, in particular in relation to land, say in the new territory in particular, where the legal boundary and the possessory boundary are often different. So it does serve some useful purpose at the moment. We feel that taking everything in the round, we should still retain the law on adverse possession. We also discuss, of course, the boundary problems in this respect. And in practice, we found that very often the boundary problems are long-rooted, and in many cases, actually, it springs back from the year of 1905 or thereabout, where there is a complete survey and done not by today's standard, not very professionally. But of course, in those days, one couldn't really put much blame on the matter. And very often, we found that adverse possession is really the only solution to some of the boundary problems. Now, then we also considered the law, what the law should be when we have registered land title. And we feel that the law would have to be completely revamped under a registered title system. And in that regard, actually, by and large, we propose a system whereby if and when we should have registered title, we will adopt the English system of requiring the adverse possessors to give notice and to the registered owner, and give the registered owner an opportunity to oppose the application by the adverse possessor for registration of his interest in the land. Bearing always in mind that under registered title, it is the land registry, the register, that counts, and it is not really by the transfer or the deed that counts. So one ascertains ownership simply by going to the land registry and find out who is the registered owner, and that is supposed to be conclusive. So if we were to have adverse possession, then of course the squatter would have to get himself registered. Now, under the registered system, if we look at the law in other jurisdictions, there are jurisdictions with registered land whereby it did not permit any squatter title at all. That is because one must bear in mind that it is the register which is the supreme, which has got the supreme say as to who owns the land. And that is why. But we feel that by and large, we can still, on top of that, have adverse possession on registered land. And we prefer to adopt the English system, which we feel really struck at the right balance. Now, we also recommend that there should be the abolition of the implied license theory. And the implied license theory is basically to say that in the 70s, there were some decisions, particularly in England, and some of them were also adopted in Hong Kong, whereby it is said that the squatters would not be able to get a squatter title if his use of the land is not inconsistent with the owner's intention as to how the land should be made use of. Now, that is a theory which would make adverse possession more difficult to get, of course. But on the other hand, we feel that there is no justification for such theory. In England, the position had been put into the right track by the Limitation Amendment Act, and there are some case law which also says that that line of decision is wrong in any event. And therefore, we feel that for the removal of doubt, we should really adopt the same approach in Hong Kong. In relation to other recommendations, we feel that our recommendation 5 and 7 are generally supported, except the Law Society and the Hung Yi Gou, which did not agree with our recommendation. And for recommendation 9 and 10, I've already mentioned that dealt with specific aspect of the decision of the Court of Final Appeal. Now, so far as the boundary problem is concerned, we recommended that the government should be urged to step up its efforts to address the boundary problems in the new territories. But of course, a resurvey of all the land in the new territories has not been recommended by us, bearing in mind the costs involved, and it does not actually by itself solve all the problems. Now, in relation to Zhou land, the land in Zhou, and because of the law, which says that if the land is held on trust, you cannot actually complete your adverse possession title unless you dispossess each and every beneficiaries. Now, if that be the case in the case of Zhou land in the new territories, having regard to the fact that every male member born by that Zhou would automatically becomes a beneficiary, in effect, that you cannot really have adverse possession against Zhou land. Now, it is an anomaly, but we feel that A, the problem is not really that acute, and secondly, we see no reason to disturb the long-established rule, which is enshrined in our limitation ordinance, which requires you to dispossess not just the legal title owner, but all beneficiaries under any land held in trust. So we really accept that this is an ancient kind of land holding institute in under Chinese law, and unless that institution of land holding is really got rid of by legislation, which is not part of our function, we prefer not to touch on this particular aspect. Well, I think basically that is a summary of our recommendation. Our recommendations, number 1 to 10, are in fact contained in our report. And I don't think it is necessary for me to read it out all over again.
好，多謝陳景生主席。
Thank you, Mr. Edward Chan, Chairman of the Subcommittee on Adverse Possession. The floor is now open to members' questions. So, members, if you have any comments to make on the report, please feel free to raise them. Yes, Mr. Tam Yu Chung. If no other member would like to ask questions, and I can ask first. Well, for the time being, we only have Mr. Tam Yu Chung, and I'll be asking questions myself, so I'll be more relaxed about the time control. Okay, so I'll give you 5 minutes, but then I'll be a bit more relaxed in dealing with that. Yes, Starily. So together with myself, we have 3 members in the queue. Mr. Tam Yu Chung, with regard to land title, I think it's a controversial issue because some people might be concerned that inadvertently their land title could be taken away from them by other people without their knowing. And what I can see now is some adjustments will be made to the system so that the limitation will be reduced to 12 years from 60 years, but then you will have to inform or notify the title owner. That is, upon 10 years, you will have to notify that person. But then sometimes in informing or notifying the title owner, in what form should you be sending out the notification? It could be problematic. For example, if you say that you have to put up in a newspaper advertisement, then the landowner might not be reading all the newspapers every day. And there is a chance that the landowners might not be aware of that. So even if you want to send out notification to the landowner, you might not be able to reach them. So my question is, in this regard, does the LRC have any proposals? Have you thought about that? Yes, Mr. Chen. Mr. Tam, first of all, I have to clarify one point. I think that's a very important point. Under the existing land system, we have not proposed that notification should be sent out because for the time being in Hong Kong, for all lands, they are unregistered land. So it's an unregistered land system. In other words, we do not have a registered land title system in place yet. So what we are proposing is that, well, as and when the land title ordinance comes into effect, as and when it comes into effect, then we will be implementing what we propose, because as and when that ordinance comes into effect, then every lot will have to be registered with the land registry, and then there will be a registered owner. And then after you have become a registered owner of the land, then there is a reasonable expectation that if you change your address and if you change your particulars, you will have to go to the land registry, informing him that, all right, my surname is Chen, and then I'm the owner of the following lots, and I'm changing my address. So in the future, with the central registration system in place, then very conveniently, you'll be able to identify who the landlord is. That's not currently available, because at present, you simply have no way of telling who is the registered owner, because there is no way that you can find him, because when you go to the land registry to do the registration, you're just registering the deed, and as to whether or not the deed is the true deed or not, there is no way that the land registry can tell. You can always register a fake deed, and seemingly you have registered it already. But then in the future, of course, you will have to have a more stringent system in order to make sure that you can identify or locate the landlord. And of course, we also understand that even for the registered owner, he could die, and there is no way that you can find out if or when he has passed away. And in such circumstances, even in overseas jurisdictions, they will have to come up with a mechanism. For example, they will have to do it by gazetto or put up newspaper advertisements and so on. So we don't have an exhaustive list as to what you should do, but then that's the general direction that we think we should take. And of course, we could easily copy the UK system, because in the UK, it was implemented in 2002, and so they have more than 10 years experience already, and therefore we can learn from their experience. Mr. Tam Yu Chong. Thank you, Mr. Chen, for your clarification. But then with regard to the title registration system, the law was enacted a long time ago, and still it has not come into effect. That's why probably if we have to do it, then that would take a lot of effort.
So maybe there is still a long way to go for this LRC recommendation to be implemented. But anyway, thank you for the clarification. Next, Ms. Sari Lee. Madam Chair, I thank Chairman of the LRC Subcommittee for your presentation. Adverse possession. This concept, to the minds of owners of old buildings and members of OCs of these buildings, it's hard to grasp. We understand the theory, but if you have visited the local communities, you may share the same feeling that for common areas, back alleys, due to historical reasons, the space is occupied, and yet because long ago there wasn't any OC, and no one had ever notified the squatters that they should not occupy the space. And these people are very concerned, because in some way it seems to be indirectly encouraging squatters to adversely possess other people's land. So I don't know whether this has been considered in your report. If you have, what is your understanding of these residents' concerns? Mr. Chan. Now, our first recommendation is whether or not we should retain this concept of adverse possession. Now, we considered it, and from the jurisprudence point of view, our existing system is one of possession. That is, as long as you possess a piece of land for long enough, or you occupy the land for long enough, And if no one can prove any titleship over you, then you are entitled to own the land under adverse possession. And that originates from the UK law, and the UK Act has been implemented for quite some time. However, in Hong Kong, we have similar laws for a very long time. It dates back to 1935 or even before that. So if it is scrapped, there may be adverse implications. However, at the same time, we need to consider different circumstances. For example, for small houses in the new territories, the property may not sit entirely within the boundary of land they own. So on this point, we understand and we have reason. We understand their reasoning. That some people may ask why, despite being the owner of the land, somebody else can take over my land. But we have to understand that the period has just recently been changed to 12 years, even in the UK. So if we say that 12 years are too short, and we should suggest another period of time, it may be a step backward. Ms. Lee, maybe the circumstances for urban land and NT land are different. For older buildings, well, it may be a step backward for them if the period is changed from 20 years to 12 years. And it's still another backward step from 12 to 10 years. And how would you address their concerns? And that is, the concern is whether adverse possession is an indirect encouragement of people to take away other people's land. They bought the flat many years ago, and at a time when no OC was set up, and the building was not properly managed, and now they're concerned whether somebody would take their share. Chairman, or anyone? Or perhaps I can take this question on Chairman's behalf. It's okay, you still have time. Now, under the existing land ownership system, if a landowner says that, for example, he has a government lease, he has a ground lease, so he is the owner, this is a misunderstanding, because under the common law, it is the possession that counts. If you possess the land, you are the owner. Even with a crown lease, it only means or it only explains the concept of title. Now, before we have this land registration system in place, there is no way we can displace the concept of possession. It's really difficult to let the public understand what this concept of possession means. Maybe I'll wait for a second round. Well, I have a follow-up question as well. First, on this concept of adverse possession, for law students in Hong Kong, you have studied this concept, you may be familiar with it. But for ordinary members of the public, it may be quite a difficult concept. And as Ms. Lee said, we often come across cases, and it's really hard to get people to understand. Now, for example, Hong Kong people may go back to the mainland and make a claim for the Chou land, which has been occupied by others for quite some time. So, according to the adverse possession concept, because there is not such a concept on the mainland, they can get back the land. But in Hong Kong, the case is different. And we have come across some cases. For example, some elderly people have allowed others, relatives or friends, to use their property. perhaps with an element of deception on the other party's part, and then for some time, after some time, because of adverse possession, the land title may be changed. And another point is on notification, as mentioned by Mr. Tam Yu Chung. Of course, I support the additional notification requirement, but sometimes it is quite hard to notify the owner, and to some it may be a nightmare in Hong Kong. You talked about corridors, and sometimes it may be just outside your door. Say for restaurant operators, they understand. So first of all, it is important to have public education. You should educate the owners not to allow squatters to claim adverse possession, and they need to be vigilant. For Hung Yi Kok, we understand why they object to the recommendations. What about the Law Society? What are the grounds? The Law Society is of the view that under the existing land system, we can still implement the recommendations. That is, you cannot have adverse possession if you have not notified the owner. It sounds good, but there are difficulties in terms of implementation. First of all, when? Now, at first, you need to notify the owner, but who is the owner? We do not have an authoritative method of finding out who the owner is. The second point is, if possession or notification is allowed, should be made 10 years later, then when does it begin to count? Under this existing concept, we do find some difficulties. So if we have a system here, and then we know in future that there will be a land registration system in place, then we should not go for the more troublesome route, because land title is a very complex issue. For example, last time when the amendment was made to change the period from 20 to 12 years, we had a long transitional period. So since we already have the land title ordinance in place, which will take effect in future since the legislation has been enacted, then why should we implement this under the existing system with uncertainty in terms of the period of time, etc.? That's why we don't recommend adding this notification requirement under the existing system. Also, for example, for a squatter who has occupied the land for 8 or 10 years, at this stage, does it mean that notification must be served at once? That is why we propose that we turn a new leaf by introducing this new requirement when the new system comes in place. If we change the existing system, it may be good for lawyers because they have more cases that can be taken to court, but things will get more complex. Now, on the notification requirement, our recommendation is to wait for the land registration regime to come to take effect, because with land registration we can find out who the owner is, whereas if we just read the deeds, we may not know. So on assignment of properties, as lawyers, very often we understand that there are technical defects in many of these deeds that cannot be addressed. The only solution is to wait for 12 years so that we can rely on adverse possession to address these technical problems. If we scrap the system, we cannot make use of this method to address the technical faults. First round, Mr. Dennis Kwok, and 2 more members in the second round, Mr. Ng Lang Sing as well. Yes, Mr. Dennis Kwok. Thank you, Madam Chair. First, I thank members of the LRC for their effort in looking into this issue, and I understand that members worked pro bono for the issue. So I thank LRC members for their time and effort in studying into this issue. Now, in general, I agree with the recommendations because for the situation in Hong Kong, we're not starting from scratch. We have a long-standing land title system in place. If all of a sudden we are to propose making changes to adverse possession, then there will be a lot of complicated legal problems arising. So that's the major principle. Secondly, I'd like to ask the administration, when is the administration intending to allow the land registration system to take effect? Madam Chair, we should invite the administration to come and give us a response. The ordinance has been enacted a long time ago, and we all know the history. I won't repeat it. I'd like to know what the administration will do. Yes, we can discuss that. Yeah, Mr. Chan, how long do you anticipate? We still have to wait. We have no say on this issue. Our terms of reference do not deal with land titles. So we just work with the government. We know that the legislation has been enacted. We understand that it has not yet come into operation. Our assumption is that it will come into operation in the future. So why don't we write a letter and ask the administration how they will deal with it? Because I think we should discuss it. We have discussed the topic of adverse possession for a number of times already. Sorry, speaker's not coming through. At the time when the bill was tabled, we raised a lot of questions.
And Margaret Ng was here, and she gave a lot of comments, and the administration insisted on passing the legislation. So it's not about expediting the implementation, it's about improving the legislation. So I'm just trying to tell you the history to this. All right, Mr. Ng Lang Sing is also in the queue. So after Mr. Ng Lang Sing has spoken, I suppose you'll be speaking. All right, I'll give you 5 minutes. All right, so it doesn't really matter because you're very experienced, so you can supplement on what we do not know. Mr. Ng Lang Sing, thank you, Madam Chair. On this particular point, what I've heard from several members on the issue of adverse possession with regard to the basic definition of this term. Well, last time when we talk about Hong Kong's asset management, we also had a similar situation. Well, according to Confucius, whatever doesn't belong to you, you should not try to possess it. But then in the course of the development in the Western world, that might have become a phenomenon that you can adversely possess somebody's property. So in dealing with certain assets, well, if you purchase something and if you are not using it at all, that would be a waste of resources or the asset. But then if you want to own it, with this law in place, and if you try to adversely possess it, then through what means have you done done it would be very important. That's why I'd like to know, in terms of the possession of the land, well, what are the means of possessing the land? Would you be able to find out, for example, if it's done some 10 odd years ago? So if they can come up with witnesses or evidence to prove that in taking over the land, in certain circumstances, there might be some problems. I'm not suggesting that it could be unlawful at all. But then, when they try to properly register the title, would there be any controversy or dispute? So have you looked into that at all? So that in formally registering the land title, what will be done about it? So I just like to know this, Mr. Chen. Well, under the existing legal system, if you have adversely possessed the land, that means that you have not obtained the permission from the landlord, and then you are possessing the land. That would already constitute adverse possession. And of course, you will have to bear in mind that you're trying to possess the land and you have the intention of possessing it. In these circumstances, or if you have done so by cheating or deception, or you have originally obtained the consent from the landlord, all right, if the landlord says that, okay, you can stay here until I ask you to leave, then that's okay, then that would not constitute adverse possession. But of course, I would understand that the law is a problem, but then adducing evidence is another problem, because very often in adverse possession cases, when it happens, we are talking about something happening about 10 plus years ago, and therefore there would always be problems in adducing evidence, but then that would not affect how the law should work. Because other than land, the limitation ordinance also provides for other things. For example, for contracts, usually the limitation is 6 years, and if you do not institute legal proceedings, then you will not be allowed to institute proceedings. So it's not just confined to land. So my view is, well, for adverse possession, I think the concept is quite established by now, and therefore there is no need for us to amend it at all. And then in the future, with the land registration system in place, then what is going to happen? Well, of course, if the administration allows some people to be registered as the registered owner, then I'm sure the administration would also have to put in place a very stringent verification system. And therefore, as far as land title is concerned, then there needs to be a very stringent verification system to suggest who would be entitled to become the registered owner, and therefore at the time of the registration, the administration will act as the gatekeeper. Well, will there be a comprehensive appeal mechanism in place in order to repeal anybody who has been registered well, I'm not supposed to be the one in charge of the land registration system, but then as a council, then of course I would think that there needs to be such an appeal mechanism in place, or else anybody can just say that I'm the landlord of the site owned by HSBC headquarters. Then how can it work if there is no such verification or appeal mechanism in place? All right, for new territories, lands boundaries, if it's to be redrawn, then that would require professional institutions and professionals to do the job. But then here it says that in some cases that might not be accepted. And if it's not accepted, then the best thing is to wait till the implementation of the land registration ordinance before these problems are resolved. So initially, these are administrative issues or just general disputes. So are you trying to resolve those in a court once the land registration ordinance comes into play? All right, that again has to do with land title. Well, that does not necessarily have to be presented before the court. If it's a major registration problem or problem, then they might set up a special tribunal to deal with these problems. But then, again, that's not the terms of reference for the subcommittee on adverse possession. All right, lining up in the queue for the second round. I'm the only one, so I'll be asking questions in the second round, and then we'll see how we can take the matter forward. All right, Paul Chair, I'll give you the floor first. Sorry, Madam Chair, I raised my hand a bit late. All right. Looking at the land registration ordinance, it was enacted in 2004. It's already the 10th anniversary, but then it has been left there without being implemented. What is going to happen? So as Mr. Dennis Kwok already said, we have expressed our concern on this. So I agree that instead of just writing a letter, we should find out what's happening. Why is it not implemented? And the LRC has made the recommendation 2 and 3, that's based on the implementation of the land registration ordinance before those 2 recommendations would be implemented. So that's my suggestion, that we should raise our concern on why it's not implemented yet. And also, back in 2006, you were already appointed to deal with this issue. And yet, it's only now that you've come up with the final report. So what happened in the course of that? Well, as we have said, we are very grateful for your hard work. So why has it taken you so long? What has the administration done? Has it delayed the process? Or is it that you have encountered some difficulties? That's why it has taken you so long to come to this conclusion. And secondly, I'd like to know a bit more about the LLC's recommendations with regard to 4, 7, 9, and 10. So, under the limitations ordinance, you're proposing some amendments. So what's the stance of the administration on these recommendations? Have they told you their stance? I understand that we have no representative from the DFJ here today, but then would anybody be able to tell us what the administration is thinking on this? Well, on the first issue, I have to say sorry about this because we might have been a bit slack in our work. It's not that we have a very disciplined timetable for us to complete our tasks, and of course we have to conduct our own consultation, and we also have to look at other jurisdictions' experience. And secondly, on this particular issue, well, just by studying the issue, we have to find out the historical background to this. Yes, we are all legal practitioners, but then that's one thing, but then to follow up on this is another issue. That's why we did spend quite a bit of time on studying the background to this. And of course, there have been some change in the personnel of the committee. And you can see that some members left the subcommittee, and we also had new members and so on. So we did waste a few years before we came up with this report. And we did not encounter specific difficulties, and no institution or organization has put pressure to bear on us. But then we have also got to think through a few issues. For example, we have also considered that, well, with regard to tenancy agreements, there are some related issues. For example, recently, if you look at recommendation 10, well, that originates from the landowner. Should the fruit of what he gets be passed on to the landlord or what? But then we find that, well, number one, this is not a big problem. And second, we do not need to come up with a specific recommendation on this. So it's not that we are just discussing the issues in the report. There are other related issues, but then after we have considered them, we believe that we should not be stepping into those areas as well. That's why we have not elaborated on that in our report. As to your second question, I don't have anything specific to supplement on this. We don't have anybody from the administration here, right? I don't understand why we have not asked them to come along this time when we review the issue. So,
in relation to the report being taken forward, that in fact the Development Bureau has advised that in consultation with the Lands Department and the Lands Registry, it is now studying the recommendations from the LRC.
Can you speak louder?
I'm sorry.
Yeah, it's okay.
Okay. The Development Bureau has advised that it is studying in consultation with the Lands Department and the Lands Registry the recommendations of the LRC.
咁樣啦，我諗。
Madam Chair, can I give some more comments if we have more time? Well, according to Mr. Chen, you explained to us your stance, and you said that if there's this land registration ordinance and if it comes into effect, you also suggest that there should be a registration system to make things clearer. But then we also understand that the Law Society has said that given the fact that we have not implemented the land registration ordinance, that's why they had some reservation about this. With regard to the notification, I understand the difficulty because if you have no idea as to where the landlord is and who he is, then you will have difficulty notifying him. But then if we don't know when this law will come into effect, then of course in the course of that, as Mr. Yen said, for people waiting in the line, or if the time limit has passed, then would that be unfair? That's why can we have an interim measure? Can we ask that if you want to give notification, if it's, well, it should not just be about putting up newspaper advertisements, because we cannot expect people to check the newspaper advertisements every day. But then can we do something like the bankruptcy ordinance requirement so that we can have some central coordination about this? So for any landlord, if they want to find out if their land has been adversely possessed by somebody else, they can also check with that registry. So can we have a halfway house here so that that would also help ease the problem, so that people would not have to just fight in the dark, so that they would be able to tell whether or not there might be some imminent danger, or they can take preventive measures to prevent this from happening. So before the land registration ordinance comes into effect, there can be some halfway house to safeguard their interests. If you all think that this is something that has to be implemented, then I don't think this is not enforceable. But then on the basis that if you have to give notification, then under the current system, well, if the landlord cannot be found, or if the landlord has already passed away and there is nobody inheriting his land, then we are actually abandoning or scrapping the adverse possession rights. Because if there is no landlord there, and no landlord can be expected not to take action if he has been notified of this adverse possession.
So we've also considered this balance. There are some who say that landowners' rights should be protected, and yet there are some others who say that landowners should not be allowed to sleep on his rights and to continue possessing the land without using it. The land, the actual user of the land, so to speak, may develop the land in a constructive way, for example, to make accommodation on the land. So for the adverse possessor, the user of the land, what about his interest? The possessor may have spent some money and time on improving the land, and we also need to consider that. And I reiterate once again that since we already have this concept of adverse possession for so many decades, if we just scrap it suddenly, we need justifications to do that. Well, I think, yes, we've heard your comment. Well, just one more point. Well, basically, in the limitation ordinance, the rights have not been extended. Well, I mean, the rights have not been taken away because of any change to the legislation. No, Section 17 says the rights can be extinguished. All right, so that's my point. We want to have higher transparency in terms of our rights, be it under the civil or criminal cases. and we don't want, and we're trying to retain this concept which allows things to happen behind closed doors. I think we need another review, but this is just my comment. Well, in fact, I'm in the second round, and let me just figure out how to deal with this. Mr. Chairman, I think the concept of adverse possession arose originally because we would like to develop land in a positive way, and we do not want to see land being left idle for a long time. But many members have made some good points today. For example, the intention of adversely possessing the land. Maybe because in the local community we have come across many cases. Well, usually this happens to older landowners, and without any knowledge, they have been subject to an adverse possession claim. So, can we include more elements in the system? For example, in the first place, how did the possession occur? And for example, maybe the landowner only owns a small flat, and the elderly owner may have a successor. And can we say that through hard work of the older generation, this successor can have possession, and it would be too easy for the adverse possessor to take away the land? Well, as Starry Lee put it just now, sometimes the actual owner had no idea of the adverse possession case until the case is all over. So yes, we do see cases in which, without knowledge of any party, the land has been adversely possessed. And another point, you don't know when the registration system will take effect. And correct, we don't know how long, and I think this is a direction conducive to its implementation. We hope that members' views as well as Law Society's views can also be considered. Mr. Abraham Shack has left. I wanted to let him speak. Well, but I think since he is very active in this regard, I think he meant to say that there are loopholes in the ordinance, and before its implementation, we should look at the loopholes that happened 10 years ago. So since we're going to write to the administration, maybe we should have another session to discuss the ordinance, and then we can also invite the administration and the relevant departments to come and explain what happens after the amendment, because this adverse possession reform will have to wait for the land titles ordinance to come into effect. Yes, Mr. Dennis Kwok. Madam Chair, I formally propose that we include this topic of adverse possession on the list of outstanding items for discussion, and we can then formally invite the administration and the LRC subcommittee, Chairman Mr. Chan, to come again, so to let us know what is going on. Well, not many of us took part in the passing of the bill then, and since your recommendation is linked with the ordinance implementation, so I think yes, I'll put this on the list and discuss it when time is right. So I thank Mr. Chan and members of the committee for attending this meeting and briefing us on the recommendations. So thank you, Mr. Chan. Let's move on to the next item.
附表3所列嘅例外罪行嘅報告書。
Next item is LRC report on accepted offences under Schedule 3 to the Criminal Procedure Ordinance, Cap 221. And we have a paper, CB bracket 4264/1415 bracket 07, which is an executive summary on LRC report on accepted offences under Schedule 3 of the Criminal Procedure Ordinance, Cap 221. And according to Schedule 3 of the Criminal Procedure Ordinance, the court is not allowed to suspend the sentence. So some serious offences have not been included in Schedule 3, whereas some minor offences are on the list. And in February this year, the LRC published a report on accepted offences listed on Schedule 3 of Criminal Procedure Ordinance to suggest that judges and magistrates can pass just and suitable sentences and including the choice to suspend the imprisonment sentence after repealing accepted offences listed in Schedule 3 of the ordinance. And I'll invite Ms. Ainsworth to brief us on the report, and then I'll also allow the Bar Association representative to speak.
Yes.
Thank you. The LRC report, as you've said, was published on the 25th of February this year, and it was proposing the repeal of accepted offences listed in Schedule 3 to the Criminal Procedure Ordinance. The problem is that under the ordinance, suspended sentences as an option is not available to the court in respect of the offences listed in the schedule to the ordinance. However, there appear to be some anomalies in this list of accepted offences, in that some serious offences are not on the list, while some less serious ones are on the list. For example, an offender convicted of unlawful sexual intercourse with a girl under 13, which is currently not an accepted offence, may be sentenced to a term of imprisonment but suspended. In contrast, the court has no discretion but to impose a term of immediate imprisonment for an offender convicted of attempted indecent assault, where a non-custodial sentence is not appropriate because it is listed as an accepted offence. Such a state of affairs can give rise to a general sense of unfairness and arbitrariness. By way of background, the concept of suspended sentences was introduced to Hong Kong under the Criminal Procedure Amendment Bill in 1971, and the creation of accepted offences was the result of strong opposition to the bill from the unofficial members of the Legislative Council at that time, who had expressed concern about the sharp increase in the rate of crime. The LRC believes that the public sentiments behind the creation of accepted offences some 40 years ago have long gone, and that the original rationale for having accepted offences no longer applies. The LRC published a consultation paper on the topic in June 2013, and the consultation period ended in September 2013. Those in favour of the proposal included the Hong Kong Bar Association and the Law Society, who generally endorsed the consultation paper's rationale for repealing the entire Schedule 3. Overall, 39 responses were received, 28 were in favour, 5 were against, and 6 were neutral. The LRC believes that judges and magistrates should not be restricted from exercising their discretion to achieve a just and appropriate sentence depending on the circumstances of the offence and the offender, including the option of suspending custodial sentences. Of the jurisdictions studied that have a similar suspended sentence power, none of them has maintained exceptions as wide and extensive as those currently applying in Hong Kong. The LRC welcomes the views of members of the panel.
好，咁跟住我哋請大律師。
Next, Mr. Andrew Bruce from the Hong Kong Bar Association, please.
The Bar Association strongly supports this, this proposal. We take the view that judges today, probably yesterday, are well equipped to make judgments about when it is right to suspend a sentence. For most of the offences on this list, you would never think of suspending the sentence anyway, for a number of reasons. First of all, the offence is inherently serious. You notice the list starts with manslaughter. The other thing is that you have to make a decision to impose a sentence of imprisonment first and then decide to suspend it. And you can only do so, you can only impose a sentence of a maximum of 2 years, and you can only suspend it for 3 years. So we're talking about, at maximum, pretty low-level offences. And if judges or magistrates make a mistake, there are appeal proceedings, including the prosecution has a very strong right of review. This is actually quite a modest proposal, very small proposal in its own way, and it seems to me that for serious offences there's going to be no change. It's just going to be where another option, possibly the rehabilitation or reformation of the offender, where he or she has done something wrong on an isolated case and there's a better way of dealing with it. So for those reasons, the Bar Association strongly supports this proposal.
Okay. Thank you, Mr. Andrew.
Thank you, Mr. Andrew Bruce. Now, members can ask questions. So far, Mr. Dennis Kwok has indicated to ask questions. So 5 minutes, but I'll give some flexibility. Okay, Mr. Leung Sing as well. Mr. Dennis Kwok. Madam Chair, I see the justifications for this proposal is very clear from the paper. On arguments against reform, that's in para 10, the only short paragraph, and that in the early 1970s, with the prevalence of violent crimes, it required a hard sentencing option, but now in the 21st century, and the courts and the judicial officers and judges have progressed, and our system has matured, and the administration's proposal filtered today is very mature. I don't think it's controversial.
Yep. In para 13, some 80% of the judicial officers are in favor of scrapping the so-called accepted offences. That's why the Civic Party will be prepared to support this proposed scrap. Next, Mr. Leung Sing. Madam Chair, on para 18, about the 5 respondents who opposed the recommendation, other than some women's groups and also Rain Lily and other NGOs, and we also have a lawyer. But what's more important is the Commissioner of Police. He's one of the 5 respondents opposing this recommendation. So is it because he's a law enforcement agent? And he's of the view that the scrapping of this would give rise to some enforcement problems. So can you supplement on this? Why has the CP opposed it? And what have you done to address his views? So why did you disagree with the CP? Yes?
Was basically a maintenance of the status quo, and the Commission felt that maintaining the status quo was not the appropriate way forward on this, and that the majority view was in favour of reform.
Yes, Mr. Ng. And there is also a 5th recommendation, point 5. If Well, for those who are of the view that they have some reservation about this, but then you can decide not to scrap it altogether, but then you can also amend Schedule 3 instead of scrapping it altogether. So, have you considered that? Is there a necessity to amend it? And of course, revising it may not be the best way out, but then have you considered amending it? And what's your consideration? Yes, Ms. Ainsworth.
The Law Reform Commission report at paragraph 5.19 talks about the difficulty of the arbitrary nature of picking and choosing between certain offences to include and certain to exclude. And it concluded that it was better to take a wholesale approach than to take an arbitrary line.
Well, for this kind of difficulty, and now you've spent some time to look into it, and then for such a list which has been in place for some time, well, back in the 70s, well, you adopted that list in order to deal with the prevailing situation, but of course the time has changed and the circumstances have also changed. But then to scrap it all together or to revise it by amending the offences, I think we should adopt a two-stage approach. And without looking into that very carefully, I have not really looked at Schedule 3 in detail. I have not really found out whether or not the police might feel that if it's scrapped altogether, then there might be problems for them in enforcing the law. If something similar should happen again, then the deterrent effect might be affected. Well, I have to say that I have not really looked into that, but then with advancement in society, that would have to be in a progressive manner, and therefore I think it's better to revise it and then to scrap it instead of just scrapping it altogether in one go. Yes?
Sorry.
Thank you.
當年突然間提出即係話。
Well, back in those years, you suggested that, well, in some cases, you're not allowed to mete out a suspended sentence, and of course, that's done very crudely, and therefore scrapping it would have to be in a similarly crude manner. And, well, what the CP has said about this, I don't think that's part of his work, because he's only responsible for catching the culprits, and it's not for the DFJ it's not for him to have any say on the DFJ's work. So I think he's just expressing his views on something not related to his work. If he's allowed to do so, then he can do anything he likes. So he can say that the sentences meted out by the court are too low. All right, we have worked so hard to catch the offender, and yet you are meting out such light sentences. So it's about whether the court is able to fully exercise its powers. All right, if there are some offences which the court might find it suitable to mete out suspended sentences, and then for relatively heavy offences or serious offences, do you think the judge would mete out suspended sentences? I think back in those days, because the situation was different, that's why they tried to allow for this mixed handling. I think we should leave everything to the court. All right, meting out two light sentences would be a problem, and then meting out two heavy sentences would also be a problem. Mr. Do you understand it? So if you say that the court is not allowed to mete out suspended sentences, then the court might then have to decide to mete out lighter sentences. I think leaving everything to the judge is not a problem, but of course the problem is whether the judge is able to do his work properly. All right, in some cases, the judge might decide to mete out suspended sentences, but then if he is not doing his job properly, then of course that would give rise to another problem. That's like giving people the freedom, and then if they do not exercise their freedoms properly, then of course that would be a problem. But then back in the 1970s, they did it too crudely, and now you try to give them the power, and then you see how they do their job. I think it's okay. So would you like Ms. Ainsworth to respond to that? Okay. Yes, Mr. Paul Chair. Thank you, Madam Chair. In principle, well, like the Law Society and the Bar Association and also 80% of the judges who have been interviewed, I think we should adopt the LRC's recommendation. I think it's appropriate because back in the 1970s, what we were worried about is now no longer our concern. In particular, if you look at the quality of our judicial officers, I think today we are more prepared to accept that they are qualified to do their job, and therefore we should not tie their hands when they exercise their powers. But what I find to be regrettable is that we don't have any representative from the DFJ to tell us what they feel about the recommendation by the LRC, and if they are in support of that, when will they be amending the law in order to implement it? Well, I'm not sure whether we can take it up with the DFJ, but then next time round, if we have similar reports, can we have the DFJs here in order to respond to that? Secondly, do we have records, in particular for Schedule 3 offences? Well, in principle, I agree that we should scrap them all together. But then in some cases, according to my understanding, in the past, there was also some experience in the course of my practice, in particular for indecent assault cases in Item 6 and also Item 9 concerning possession of offensive weapon. Well, these could be very serious offenses, but then at the time of meting out the sentences, if there is no allowance for meting out suspended sentences, originally they might have wanted to mete out a more heavy sentence, but then for the purpose of meting out the suspended sentence, they might decide to mete out an imprisonment term of less than 2 years. So, Mr. Andrew Bruce.
關於嗰個有呢兩方面嘅困。
So, would there be difficulties in relation to indecent assault cases and also possession of offensive weapon? So, are there more cases like that?
Right, but you're now wearing the head of the
Yes.
Law Reform Committee. Yeah.
Yes,
So,
that's right.
Yeah.
In relation to implementation, the question on that, I believe that the report is being considered by the administration at the moment. It was only published relatively recently, so the recommendations are still being studied in detail.
Any idea as to when it will be sort of a decision will be made regarding the proposals by the Law Reform Commission?
I can't comment on that, I'm sorry.
All right.
Okay. 跟住係啊
All right, next, Emily Lau. Madam Chair, I'd like to ask this. Well, Para 18 says that those respondents who are opposed to the recommendations include Association Concerning Sexual Violence Against Women and also Rain Lily. They are both very concerned about women's interests, including that women are subject to sexual violence. So has the LRC considered this very carefully? All right, according to the chair, you said that after the meeting, we'll be dealing with the giving of evidence behind a screen. All right, those are very minor issues, and for so many years you have not really been able to do it. And now you're doing this, and that has caused some disturbance or that has caused some unease on their part. So what have you done? Why do you have to do it, Ms. Ainsworth?
the concern of the women groups.
The concern of the women's groups was aired during the consultation exercise, and it was taken very careful account of by the Law Reform Commission in formulating its final recommendations. But the consideration was that this would only ever be used in very rare cases where the circumstances of the defendant was such that imposing mandatory imprisonment would not be appropriate. So perhaps with very young defendants, boyfriend-girlfriend situations, things like that. So that's why they decided in the end that even with relation to something like indecent assault and sexual offences, that it should be also included in the list to be repealed.
So, Madam Chairman, has that been explained to these women's groups, particularly Rain Lily? because they really have very genuine concern and concern that the administration is not very sensitive about their worries, and also the legal profession, because I understand the legal profession doesn't want to have all the screen in the court. So, but these are very real concerns which have been expressed for many years, and it seems that they have always been brushed aside, and many women get attacked, and they don't get much protection. This is a very, very regrettable situation.
Hi, Ms. Ainsworth.
Well, I'm just expressing the final conclusion that the
I know
Law
you
Reform
are,
Commission
yes.
came. But obviously it will be something that the administration will need to consider when it's looking at implementing the recommendations.
Yeah.
Well, Madam Chair, I think it's very important for the administration to take all these points on board. I mean, okay, there may be very strong reasons for taking forward the recommendations, but the worries of the women's groups should be considered very seriously, and to set their minds at ease, rather than to just say, oh, go ahead, go away, you're just a minority. I just don't think this is acceptable.
Yeah. 我希望Miss Ainsworth 你聽到啦，但唔止聽到咁嘅。
Ms. Ainsworth, you have heard it, and it's not just about noting that, because there are two members who are particularly concerned about that, and they are not here now. But then Ms. Emily Lau just raised her concern. I'd also like to follow up on this, because during the last term, we also had several hearings on sexual offences and their victims, and they like to give evidence behind the screen. And some of the names here duplicated those appearing at the hearing then. Well, they are concerned that with the amendment in law, that might send out a message to the community that the sentences will become lighter. Well, I can see that no other members have expressed alternative views. That's why I'm supplementing it. So they have expressed this concern, as far as I can recall. And I also remember it was also Mr. Andrew Bruce who was here, and he's also very supportive of the amendment on this occasion. And as far as I'm concerned, I think for the defendant, of course, they would welcome this. And objectively, I don't think that by giving this to the court, it would necessarily mete out lighter sentences, or if it has more discretion, then in the more serious cases, they would not just allow the defendant to get off the hook easily. But then for the women's group's concerns, well, they are concerned that for the younger people, in particular, the sex offenders or people who might have committed offences of indecent acts, after the amendment, would they be given lighter sentences? That's why I've been emphasizing that with this in place, you will have to step up publicity so that they would know that even with this discretion, it doesn't necessarily mean that the court would mete out lighter sentences. It's just that the discretion power would be in the hands of the court.
All right, but I still would like to hear your explanation. 80% of the judges are for this proposal. What about the remaining 20%? Could you also tell us very clearly for the record of the panel? Para 13, the majority. And just now you used the term very rare cases. So that means there are rare cases. So do tell us, for the sake of the women's groups and the opposition groups, so that we can explain to them. Para 13, 18% are for, meaning that 20% oppose.
The situation with the judges, again, I think it was right. I'm sorry. It's at paragraph 5.43 of the LRC report. It says, a few judges and judicial officers who did not experience difficulty arising from the statutory restriction accordingly saw no need to remove such restriction. And then the reasons for the minority view that the statutory restriction should be retained are as follows, and it lists 4 reasons. 4A, indecent assault cases are becoming prevalent. B, B, the offence under Section 33 of Cap 245 is serious. C, removing the restriction may send a wrong message to the public. And D, removal needs community consultation. So those were the views which I believe Rain Lily and others were expressing.
So
of the minority view, as you mentioned, that a wrong message may be sent to the public, and that such crimes may also be more prevalent. And judicial officers and judges were consulted, and deputations also expressed their views here before. And I think for this panel, some members who have spoken have expressed reservations. So let me ask members. First of all, who else would like to speak? If not, I think, Madam Chair, since we still have time, I'd like to respond to the question on indecent assault and POW, possession of offensive weapon, whether there is such difficulty or not in their experience. For Mr. Paul Chair's question, would you like to give? Sorry, my question was directed at Mr. Andrew Bruce. All right, sorry. So this is a question from Mr. Andrew Bruce.
As far as indecent assault, I don't have statistics, but it is my strong impression that this is an offence which has increased in the last 10, maybe 15 years. But that, as that has happened, the range of circumstances in which it is committed have also been demonstrated to be very wide. And let us not forget that a suspended sentence, the law says it can only be imposed in exceptional circumstances. That's what the law says. So you're not changing things all that much. So the accused person would have to demonstrate after conviction that this is a sentence which, for good reason, compelling reason, should be suspended. So you've got to understand the change here is not that great. For any other more serious sexual offence, for instance, rape, the idea that you look, remember, if it's a sentence above 2 years, you can't suspend it. So the idea of a sentence of 2 years or less for a rape is just plain silly. As far as possession of offensive weapon, or, for example, the offences under the Weapons Ordinance, the next section down in this schedule, there's also a range of circumstances in which this occurs, from the silly young kid who gets himself in a tangle to somebody who's carrying a weapon for quite nasty or violent purposes, possibly to do with public disorder, possibly to do with something more serious. And it seems to the Bar Association to deny a magistrate or a judge the ability to make a judgment about the seriousness of the offence. And let's not forget, deterrence is not the only sentencing concern. Reformation and rehabilitation are also concerns, and that would be something which might cry out for a suspended sentence. In other words, you do this again, young man or young woman, and we'll deal with you in a very different way. So it seems to the Bar Association that this is a circumstance where essentially trusting judicial officers to be sensible is a compelling argument. If I can just address one other thing which is not on topic for Ms Lau, there was a judgment of Justice Zervos about 3 months ago on screens for sexual offence cases, which I personally regard as a very powerful judgment, and I would think you probably won't need an amendment to the law after that judgment. But anyway, that's a topic for another time. But in case she was not, unlikely, but in case she was not aware of that, I thought it right to bring it to her attention. But these are, as I say, the change here is not that great. And it's a change which, if it goes wrong, the Court of Appeal has powers to put it right.
Hi. Now, Mr. Andrew Bruce.
Well, Mr. Andrew Bruce just now gave his take. So why don't we do it this way? We have members who have reservations, and their major concern is that a wrong message will be sent to the public. And for the offences listed, they don't only include sexual offences, they also include things like possession of arms, without a license, so on and so forth. And I think you should explain to the public, make more effort, and explain to the public that the sentences will not become lighter. You're just giving judges and judicial officers more discretion. This is to give more trust to our judicial officers and judges. And the sentences may not necessarily become lighter. That's why we understand very well why 80% of the judges and judicial officers supported the proposal. But you have this responsibility of explaining to the public so that we don't send the wrong message to the public. I think on the record we are going to request as a panel that you step up in educating and publicizing the proposal to the public. Ms. Ainsworth?
We'll pass those comments on to the administration.
Yes.
Yes, please don't just pass the comments. This is our request coming from concerned groups. We need to be accountable to them. So thank you. Next item now. Thank you. Proposed creation of one permanent post of Deputy Principal Government Counsel in the Civil Division of the Department of Justice. The LC paper CB-4/1415/08. The administration's paper entitled Proposed Creation of a One Permanent Post of DPGC in the Civil Division of the DOJ. The other paper, bracket 09, a background brief on the relevant item prepared by the Electrical Secretariat. Now, the Department of Justice would like to create a permanent post of Deputy Principal Government Counsel in the Civil Division at the DL2 level to replace the soon-to-be expired supernumerary civil service post of DPGC. The purpose of setting up this post is to continue with the work of promoting and facilitating the use of mediation for dispute resolution in Hong Kong. And I'll invite the administration to walk us through the paper. A member of the DOJ, please. Madam Chair, the DOJ has set up a working group to take forward the work required in sustaining the promotion and development of the wider use of mediation as a means of dispute resolution in Hong Kong back in 2007. And in September 2010, the Deputy Principal Government Counsel post was created in the form of NCSC for a period of 3 years. And then in April 2013, a time-limited civil service post was created for 2 years of the same position. Now we see that the post should be regularized for work to continue, and the DPGC will be responsible for the working group or for the mediation team. This post will be in charge of the team. First of all, it is responsible for giving recommendations to the steering committee on mediation, and there are 3 subcommittees under it, and the mediation team provides support. And also, he is required to oversee the exemptions for communication in the process of mediation, also to study the possibility of an apology legislation, and there are also more practical work like the mediation week, and also to oversee the operation of the mediation or the Hong Kong MAAL set up in 2013, and the details of his work is set out in Annex B and also in Para 21 and 22. We hope that this post can be created. Otherwise, we may need to suspend the work. Thank you, Mr. Chair. Members, Mr. Dennis Kwok. Thank you, Madam Chair. I have a question. Of course, we support the development of mediation, and more manpower is needed. However, I'm looking at this chart of the civil division. Would the DOJ please explain who is responsible for arbitration? I am concerned about arbitration. I'd like to know whether there is sufficient manpower for arbitration and which officer is responsible. Mr. Chair. The policy division is responsible for litigation, not arbitration. Now, in promoting arbitration, we're lagging far behind Singapore, and in terms of manpower and resources, they have invested heavily in this area. So, whilst you increase manpower to promote mediation, I wonder if it's also necessary to increase manpower for promoting arbitration. Madam Chair, as I understand, the department in future will undertake a review on mediation as well as arbitration to see whether there is room to better coordinate work in these 2 areas.
So there'll be new proposals later to increase or promote mediation and adjudication and arbitration, and there'll be more manpower for that. Well, we don't have any immediate plan for that, but then we do not rule out any possibilities. It depends on our work plans and the manpower that would be required to implement them. I hope that the director and other DFJ colleagues can really work on it, because if we do not catch up, then there'll be a lot of arbitration cases which will go to Singapore, because recently, in conjunction with the DFJ, we went to Burma or Myanmar to promote this, but then people said that they would immediately go to Singapore if they had such cases, but then that's because they started the promotion back in 2004. That's why, in the minds of many lawyers in Southeast Asia, when they want to do arbitration, they immediately go to Singapore. But then if we want to catch up, we can. Yes, Director. I can also supplement on this, but then that does not directly relate to manpower. The DFJ attaches a lot of importance to promoting Hong Kong as the adjudication center in the region. In fact, just a few days ago, we issued a press release, and it's also uploaded on the web. informing many people that in the former central government offices in the West Wing and also in the French Mission building, some related groups will be given some office space to do that, and we have invited the relevant groups to submit their application for the use of the area, and a lot of efforts will have to be put in, and that's underway, and we have been doing that very rigorously. Yes, Mr. Kwok? I'd also like to follow up on this. First of all, I support your proposal that more resources be given to the DFJ to promote mediation in a community. If we are prepared to go for mediation in resolving our disputes, then more disputes can be resolved by way of mediation, and therefore that's something that we should promote and advocate. And I'm also glad that you're prepared to launch the apologies legislation, because very often when there are disputes, what's needed is a word of sorry. So if you are prepared to look into it, last time we also participated in your international seminar, and it's a very good thing. I hope that later on you can come up with more concrete actions to follow up on this. And just now, as Mr. Dennis Kwok also talked about the issue of arbitration, indeed, Singapore started this very early, and they've done a remarkable job. Well, back in 1993, when we started to look at the arbitration legislation, indeed, we paid a duty visit to Singapore immediately. But then, as the disputes between Hong Kong and the mainland increases in number, we can see that the arbitration center in Hong Kong would also be an international arbitration center, in particular in cases involving the mainland and Hong Kong. This would be the preferred place of adjudication. In particular, for overseas investors, if they have any disputes with the mainland, they would always come to Hong Kong to adjudicate. So in this regard, well, in other cases, they would have the state giving them the resources to promote it. And in Hong Kong's case, we are relying on the mainland as our hinterland, and where there are disputes, and given the fact that Hong Kong has this common law system, I think we do have an edge. Therefore, we should provide more resources to support them. And just now, the director also mentioned that you would be relocating to a new office. Yes, we have discussed that before, and we also understand that even within the arbitration center, some colleagues said that after the relocation, that would not be, they would find it more inconvenient, in particular when they try to promote it. And, well, you're going to relocate to the former CFA building. Well, I think that's a good thing. But then I think it's more important for the administration to provide greater support to them. I think that would help. So I would also like to say that I support this. Yes, Ms. Emily Lau. Madam Chair, in principle, I support this. But then, in the paper, with regard to the way forward, yes, a number of things have been spelled out here, but then apparently they are not very confident about it either. And people like to institute legal proceedings, in particular those with the resources. They just think that, well, they don't get what they want, and therefore they would go for litigation. So in how many cases have they gone for mediation without going to the court? Or is it that it will take some time and effort before you can do it? Or is it that the arbitrators are not good enough? That's why people may not have had sufficient confidence in them. So how confident are you in encouraging people to go for arbitration and mediation? Well, to be honest with you, we don't have all the figures. The figures that we have got hold of are figures published by the court. These are public. These are in the public domain. With regard to people using mediation to resolve disputes, well, the number of cases has gone up. And as far as the administration is concerned, during the past few years, we have also dealt with some 90+ cases, and you can see that in the court, whether it's the Court of First Instance or the District Court, you can see that the cost involved would be relatively low. because you're just talking about some 5 or 6 hours, and you would spend some $17,000 to $18,000, and then you can have the case resolved. So on the way forward, we said that we will have to establish this culture of mediation. And of course, for members of the public, they will have to have better understanding about this. That's why in March this year, we have issued a new API on TV and also a radio API. And we have also organized this mediation week. And we managed to invite many SMEs. And they have been invited to attend some of the talks. So through such initiatives, what we are talking about changing culture. And as the chair said, there are many merits to this, but then it takes time to promote this. And what we are thinking about, well, in terms of the figures, we may not be able to collect all the data and figures within the near term, but then other than court figures, would we be able to collect data from elsewhere? We are looking into it. Yes, Madam Chair. Emily Lau? Yes, on the collection of figures and so on. Of course, that's necessary if you need to spend more money on that. And also, well, honestly, if this is something good, then Hong Kong people are really very smart, Madam Chair. If there is something that good, how would they not be fighting for it? They would have fought for it because it takes less time and is less costly. So they would have been very crazy about this in the first place. But then that has not happened. Why? Obviously, they don't think that this is something that they should go for. So have you considered that? So apparently, you're suggesting that it's so good, it's so cheap. So people would have fought for it. Why have they not? And also on the quality of the arbitration, and also it's about well, it's by word of mouth. So if they have used the service and if they think that it's good, then of course they would also tell other people about this. But then that has not happened. Why? Mr. Chuck? Well, let me try and explain it, and then I'll see if Mr. Lai or Mr. Lee would like to supplement. As I said, yes, we would like to promote mediation, and we have done so for several years now. But then this year, as you can see, if you well, I hope that you can see that in 2014 we have put in more efforts. So in a community, if they can see that in their daily life, for example, for the EPD and also the FEHD, well, government departments have been approached, hoping that they can also go for mediation, for example, for garbage problem or water seepage problem. If they can try to resolve those disputes by way of mediation, that would also be a good way out. And in terms of publicity, yes, we have to step up our efforts. So I'll see if my colleagues have anything to add. Yes, Mr. Lai. Thank you, Madam Chair. In fact, in promoting mediation, well, we will have to work on 3 fronts. One is with the judiciary, second with the administration, and third in the community. Well, Mr. Chair already explained the situation with regard to the government through the steering committee and also the 3 working groups under them. Under it, a lot of work has been done. For example, in March this year, we had the mediation conference, and we also had 24 seminars on mediation. And I believe, Madam Chair, you've also taken part in one of the major events, and the effect has been quite good. And in the next couple of years, we'll be focusing on the 9 sectors, including the SMEs, the financial services sector, the business sector, the medical sector, and also the community, essentially building management, and also domestic disputes. So the direction will not change. In particular, in the policy address and also in the budget, it has been made a regular government policy. That's why in the paper, we have proposed to turn the post a permanent one, so that we can have this DPGC post in order to continue to support the work. As far as the judiciary is concerned, in January 2010, we issued this Code of Practice or Practice Direction 31, so that for people going for litigation, and if they do not go for mediation, then even if they win in the case, and the court has the power to award the cost accordingly. And if you do not have justification, then the court might not award the cost to you. So we will also be working with the judiciary. We have spared no effort. And I think that's clear to all. And also in terms of promoting it with the government and also with the community, we have also set up this council, and we have been stepping up our efforts. And for other mediation groups in the community, we have been working very hard to promote the merits of mediation in terms of cost saving and time saving, so that the public will have a better understanding of that. It's not just about members of the public. I think the professions, including the lawyers, if they can be bought in, then they would also be more prepared to go for this, so that more people will be willing to use the service. Chairman, have you heard very good reputation or very good review about this, so that they would say that this is something really very good, you have to go for it? Or is it that for people who have used the service, they would say that, well, never again? Madam Chair, to be honest, if you want to get the statistics, I'm afraid I do not have them for Ms. Lau. But then I'm not asking for figures. I'm asking for reviews. So have you got very good reviews? Or is it that everybody is criticizing it after they've used the service? Ms. Lau, we understand why you have said that in 2013 we did this mediation first conference, and we managed to find a user of the service, and he shared his experience, and he felt that mediation did help him solve the problem in terms of the time spent and also the money spent, and the court time has also been saved. And there would be an uncertainty if he had gone to the court, and therefore in the end he resolved the matter by mediation. As in overseas countries, that would take some time to build up the confidence amongst the users and the public. And in the past, we have come up with this regulatory framework. We have spent a lot of time on that. That's why for the qualification of the mediators, we have put in a lot of efforts, and now we have a pool of mediators available. So the way forward would involve us promoting it amongst the public. And there should also be more experience sharing session. And we also have to understand that for mediation cases, we will have to keep the confidentiality of the cases. But then we have to allow people to understand the merits of mediation, and then they'll be prepared to go for it. So in terms of the APIs, the slogan is mediation first. It's a win-win situation. We started that in March, and we tried to introduce the slogan. We hope that then that would come with better reviews. All right, they've worked very hard.
So let me give my take. I am in the second round. First of all, for the past few years, I have been an arbitrator, and I strongly encourage mediation. Even before you made any promotional effort, from Lehman Brothers incident, we started to use the financial dispute resolution mechanism, and it's the disadvantaged party stands to benefit, because when those with less financial means would find it hard to take the case to court. For family disputes, however, it may be the situation may be different, and I am happy to hear that just now. You mentioned that even as legal costs are concerned, the courts would also encourage the use of mediation. And for compulsory sale or auction, now the parties are required to go through a necessary procedure to use mediation, which is good for both parties. It is good if the case if the case is not taken to court, because many can't afford litigation. And as far as my experience is concerned, for disputes over management, building management, well, you may seek help from the legal sector, but for financial disputes or other more specialized building management, it takes not just one legal practitioner, but the team, in order to have a higher chance of success. So my experience to share with you is that in the community, usually I advise local residents not to take the case to court. If you ask a small household to take the case to the court, then ultimately they may not be able to afford the cost, and the whole household would disintegrate. So please, instead of devising slogans, make more effort and be more sincere in promoting the use of mediation, in particular to the legal sector. So on this principle, I support you. Mr. Ng Sing, you have a question? Oh, you want a second round? No, I haven't even spoken. Oh, you raised your hand in the first round. All right. So I let Mr. Ng ask your question as well. I have this discretion to extend the meeting. In para 8, the last sentence says that something like in other promoting mediation in other sectors, including but not limited to construction, education, family, financial, insurance, and legal. Well, first of all, if you want to take a case to court, definitely the legal sector will be involved. So it's quite laughable that you need to promote mediation in the legal sector. But another perspective is this, from a layman's point of view. Is it because of a direct conflict of interest that the legal sector would not like to resolve disputes through mediation, and they'd rather take the case to the court instead? And have you encountered any difficulties in your promotion work? I'd like to hear from you on this point. And secondly, for the Public Education and Publicity Subcommittee, you need to include the legal sector as well as the engineering sector. We have renovation work of a wide range, and I don't see any participation from the engineering sector. And thirdly, any chance legal aid can be applied in mediation as well? Otherwise, definitely, legal practitioners would invite litigants to, or applicants to, take the case to the court instead for the sake of their livelihood. Let me answer Mr. Ng's first question, whether there be any direct conflict of interest with the legal sector, and on the Public Education and Publicity Subcommittee, whether we should include the engineering sector as well, and thirdly, whether legal aid can be applied for in mediation. Now, on the first question, the legal practitioner may ask, well, why don't I represent you in the court instead of using mediation? Well, in 2009, the court, or the judiciary, issued the Practice Direction 31, and it's a very important measure to go for mediation first before taking the case to the court. If mediation has not been considered, then there may be cost implications when the case reaches the court. It will be a factor considered by the court. And I'll defer the other two questions to Mr. Lai. Yes, let me supplement. Initially, when it was first introduced, well, as Mr. Ng understands the issue, there are practitioners in the legal sector who resented this new approach. So we need to make more promotional effort, because not all in the legal sector support mediation. For the remaining two questions on the Public Education Publicity Subcommittee, we do have representatives from the legal and engineering sector. As for legal aid, mediation is covered. Yes, so one can apply for legal aid for mediation. or can one apply for legal aid simply for the mediation process, or must litigation be involved? As I understand, a litigant may apply for legal aid, and the legal aid cover expenses for mediation. So that means mediation in the process of litigation. So one cannot apply for legal aid in the first place just for mediation. No, Madam Chair. Now, in order to apply for legal aid, one of the criteria is that the applicant should go through a means test for the case, and if the litigant would like to go for mediation first, then the legal aid covers expenditure or expenses for mediation. Now, Mr. Ng, I think your question is very good. Maybe when we discuss legal aid, we can ask the legal aid department whether we can save our funding for legal aid. I understand you asked the question because you'd like to see whether we can save up after this is introduced. Well, so if there are no other questions, I thank representatives from the administration and Department of Justice and Mr. Ng Leung Seng and Ms. Emily Lau for attending the meeting, because this is winter's solstice and this is the last meeting, and I thank the Secretariat as well. I'll see you again after New Year.